Hello, this is Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Will Scharf, one of former President Trump's attorneys. He is a candidate for Missouri Attorney General and a former federal prosecutor. He's going to react to the justice's line of questioning during arguments last week over the former president's claim that he is immune from prosecution for conduct while in office. If Trump were to win his argument, many of the charges he's facing in courts up and down the East Coast would be shut down. But before we get to his attorney, I wanted to note that the justices also heard a few major disputes in April worth highlighting. In one case, they took a challenge to an obstruction charge facing hundreds of January 6 defendants. In that dispute, one of the defendants said that the government is using a statute specifically related to obstructing an official proceeding too broadly to target these January 6 defendants. He says the law applies to witness tampering and evidence destruction, that sort of thing. The justices appeared split ideologically on the matter. They also seemed divided on two other cases recently argued. One over whether cities can hand out civil fines to homeless people or if that violates the Eighth Amendment's ban on cruel and unusual punishment. The other dispute recently argued was about whether or not states that ban abortion have to perform them in hospital emergency rooms under federal law. On that topic, several of the GOP-appointed justices seemed to question how the Emergency Medical Treatment and Active Labor Act, which applies to hospitals that take federal Medicare money and requires them to provide stabilizing care, would trump state abortion laws. All decisions on the cases are expected during the next 8 weeks, as the justices typically wrap up their term, issuing all rulings by the end of June. The final case argued during this session was over former President Trump's immunity claims. As the justices weigh what to do with it, the trial in D.C. has been put on hold. It is the case where former President Trump is facing charges related to his challenge of the 2020 election results. Will Scharf explained to me what could happen depending on how the justices rule. Thanks so much for your time. I just wanted to ask you a little bit about yourself before I pick your brain about what you made of the immunity arguments last week. I saw that you're a candidate for Missouri Attorney General. I'm a Mizzou grad, and I love the Show Me State. So I had to mention, I think some of the best people are from the Midwest.
Yeah, no, it's interesting. Our team is actually quite Missouri heavy. John Sauer, who argued for us at the court, a colleague of mine, is a proud Missouri guy. Michael Talent, who's another lawyer on our team, is also out here with us in St. Louis. So it's a bunch of Missouri guys taking on that crooked Department of Justice and putting in a pretty good showing for ourselves, I think.
Yeah, we have to have more people from the Midwest come in and kind of fix D.C., I think. Let me also ask you, so I saw you're a former federal prosecutor. On that, have you ever seen a prosecutor like Jack Smith try to rush such a complex trial in the way that he has been doing with former President Trump?
No, it's crazy. I served for about 2.5 years in the U.S. Attorney's Office in St. Louis, doing mostly violent crime cases. With a case of this complexity, the idea that with millions of pages of discovery in both the D.C. and Florida prosecution, the idea that a case like that could be ready for trial in 3 months or 6 months is just patently absurd and doesn't pass a basic smell test to anyone who's familiar with federal criminal practice at all. I mean, I had carjackings, armed robberies, cases like that dragged for years because where you have complex evidence, the defense has a right to examine it fully, to test it, to request more evidence. It's entirely routine for cases much less complex than what we're dealing with to take a while. And I think that, when you try to expedite our entire system of justice, when you try to move on a fundamentally political timeline instead of a legal timeline, that does tremendous damage to a defendant's core constitutional rights. To have their right to counsel, their right
due process,
to have,
right?
Yeah, exactly. I mean, just the whole basket of rights guaranteed by our Bill of Rights is really impacted, and that's been one of the most outrageous aspects of this whole endeavor. I'll also say that it's been longstanding Department of Justice policy that you, first of all, you never. Prosecutorial decisions are never supposed to be made on a political timeline. They're never supposed to even appear to have been made on a political timeline. And there's longstanding DOJ guidance that you don't bring cases during elections to prevent exactly that sort of inference of political influence in your charging decisions and your prosecutorial decisions. Jack Smith's prosecutions have gone in completely the opposite direction.
And I saw, I was on that topic. I saw, I think it's Representative Stefanik filed an ethics complaint against Jack Smith on that. I think there's you cited the DOJ policy on not bringing a case like this in an election year or so close to an election. Do you expect anything to come of that?
I don't know, but I was glad to see that Elise did that. She's been a fighter for us on a number of different fronts now. And I think she's absolutely right. I think any fair-minded person who looks at the Justice Manual, who looks at the way that DOJ normally does business, can see that this special counsel's office has run roughshod over normal procedure, all with a goal of trying President Trump at the height of a presidential election, which is crazy. I mean, in December, they filed a very, very rare motion. They moved for certiorari before judgment at the Supreme Court to essentially short circuit the entire appellate process in our D.C. Immunity appeal. And the only reason provided for that, if you really cut to the bone of their briefing, is what they described as a public interest in bringing this case to trial quickly. They're admitting, they're saying the quiet part out loud, that their objective here is trying President Trump before the November election, which is flatly contradicts longstanding DOJ policy about politics and prosecution.
Yeah, and on the speed aspect, I looked and I saw it takes I think the median is 26 months in D.C., for a defendant to have a jury trial. That would, from indictment to jury trial, that it would be well into 2025 for Trump. So it's, it's obvious, it's just very quick.
And a lot of those cases, when you consider averages in that way, a lot of what you're talking about are relatively simple felon in possession of a firearm charges or cases like that. That just, you're talking about orders of magnitude in difference in terms of complexity of evidence with something like the D.C. prosecution against President Trump, where, you have potentially hundreds of witnesses, millions of pages of discovery. And again, Jack Smith wanted to move that to trial 3 months after he indicted it. It's just crazy.
I believe I saw you in the Supreme Court courtroom at the counsel's table during oral arguments last week. And then afterwards, when you left with the legal team, what did y'all think of the line of questioning?
Yes, I was in the second seat for those arguments and obviously worked closely on this case going back to when it was in the district court. We were, I'd say we came out of the court cautiously optimistic. The justices seemed to be viewing the case through exactly the lens that we wanted them to, which is what damage are we going to do to the institution of the presidency if we don't recognize immunity here? That if a president can be indicted the day he leaves office for all of his official acts in office, how is that going to chill presidential decision making? How is that going to impact future presidents, and not just President Trump or other previous presidents? And that's exactly the frame of reference that we approached this case through. So we were very heartened by that. And Michael Dreeben, the attorney for the special counsel's team, had a lot of trouble answering exactly those sorts of questions. And the solution that he sort of ended up at was this weird idea that presidents could have immunity essentially if they first consulted with their attorney general. And the constitutional ramifications of that argument are pretty crazy. I mean, his argument was basically to place DOJ in our constitutional firmament above the office of the presidency, whereas our Constitution sets out the exact opposite system, where the Attorney General and Department of Justice answer to the president. So it was a very strange argument, but we thought the questioning was very insightful, and we certainly think that the Supreme Court is primed to take action here along the lines of what we've suggested.
I know Chief Justice Roberts is often looked at like the middle of the court, and he said, I forget what the exact quote was I used in my story, but he basically said he showed that he didn't agree with the lower court ruling, basically that there's no immunity. He basically said, I think it was like a president could be prosecuted because he's being prosecuted, which he, was like, that doesn't sound right. So on that, if the court was to rule, that the president is immune from official acts while in office, would they lay out a test of what constitutes an official act? And then in reality, if that's what happens, could you walk us through what that would mean for trials? Would that go back down to lower courts, and then would there have to be proceedings on each charge?
Sure. Yeah, you're absolutely right. That colloquy between Chief Justice Roberts and Michael Dreeben was particularly eye-opening. Chief Justice Roberts described the D.C. Circuit's opinion as tautological. Basically, that they're saying that, well, of course he can be prosecuted because he's being prosecuted, but that doesn't answer the question at all. And I think Michael Dreeben had a lot of trouble defending the D.C. Circuit's opinion and almost conceded that its reasoning was deeply flawed, which certainly indicates that there are problems the Supreme Court has to deal with here. In terms of process going forward, I think there's a neat roadmap from the civil immunity context. In 1982, the Supreme Court recognized that presidents have absolute civil immunity for their official acts in office. That's in Nixon v. Fitzgerald. And actually last year, the D.C. Circuit dealt with this issue in a civil case arising out of January 6th against President Trump, where it considered the acts in question. I guess I should say it remanded the issue back down to the district court for consideration of which acts were official versus private conduct. And the reasoning that it basically said the district court had to use was, what's the actual character of these acts? Were these actions that were made using official resources, using the official White House office, using White House personnel, or were these acts taken in a private capacity using campaign funds, campaign personnel, et cetera? We would love for the Supreme Court to basically use a similar, to frame things similarly here, and tell the district court that it needs to do the difficult work of teasing out, with respect to all the different allegations in the indictment, are the acts that we're dealing with official or are they private? And with respect to many of the acts in the indictment, it's absolutely clear that they were official acts. Things like ordering the Department of Justice to investigate election fraud or considering replacing the acting attorney general. Those are acts alleged in the indictment that are clearly official acts by any standard, certainly under the blazing aim standard that the D.C. Circuit set out. So the process going forward here would basically be the Supreme Court would define the scope of presidential immunity. It would then remand back to the district court, likely for proceedings, to determine which acts in the indictment are immune and not immune. And those proceedings would have to occur, obviously, before trial could occur. If we disagreed with the D.C. district's opinion, we would then have, I believe, a right to take an interlocutory appeal of that and take their decision back up to the D.C. Circuit and ultimately potentially back up to the Supreme Court. So that's the process that I think is likely going to play out here, that the Supreme Court will define some scope of presidential immunity and then remand back to the lower courts to determine how to apply that scope of immunity to the facts at issue in this case.
And then, so that's like, we're talking about obviously the DC case, but how would that kind of ruling also, would it impact like the trial and charges in Florida and also Georgia? Could that be like, I guess, a framework those courts are going to have to sort out too?
Yeah, I think certainly with respect to Georgia, there's a ton of official conduct implicated by the indictment there. I think Florida, there is some as well. And we've made that argument in front of the district court in Florida. Less so in New York, but there are official acts implicated by the New York indictment as well. So this is an issue that the courts are going to have to deal with. And I think the haste with which President Trump was indicted in all these different courts and the speed with which they tried to bring these cases to trial shows that they really weren't paying attention to a lot of these very thorny legal issues that come about when you take the absolutely unprecedented step of indicting a former president.
I guess my last question, and I agree with you, I think especially with the Chief Justice Roberts' comment that the argument seemed to lean in y'all's favor. But if for some reason there were to be a trial ahead of November, which it doesn't sound, even if it's remanded and all the different steps I have to take, that would happen. But if it was, would the court consider that the election in terms of like venue and jury selection? Because obviously I know DC is not necessarily like a venue favorable to former President Trump, but the idea that an election is about to occur, like, would it be viewed as even more political? Is that something a court should consider?
Yeah, I think it would create a profound problem certainly in terms of jury selection. Pretrial publicity is always something that courts consider in terms of how they go about jury selection. I think there would be any number of problems that would arise if there were to be an attempt to force this case to trial before the November election, especially at this point, where if the Supreme Court were to return a ruling in June, typically the Supreme Court's mandate doesn't issue for a month after that, so we're into July. We were still several months before trial when we first got our stay in that D.C. case. So you would really have to truncate the timeline in a way that would be very unfair to President Trump to even have a chance of getting that case to trial before November. So I think the chances of that are quite slim. But yes, if you were to try to force this case to trial before the election, that would create, I'd say, profound due process and constitutional rights implications for President Trump. And that's why I think it shouldn't happen.
Mm-hmm. Well, thank you so much for your time. Before I let you go, is there anything that you want to mention that I didn't ask you, or do you have like a guess about when we're going to see a decision? I know everything usually comes out by the end of June.
With a case
thoughts?
like this, where you'll likely have multiple opinions, I would be very surprised if we got a decision before the last couple of weeks of June. It's worth noting the Supreme Court also has the Fisher case on its docket. They heard arguments in that.
Yes, I was there for that one. The January 6th defendant over it's the obstructing an official proceeding issue, correct?
That's 18 U.S.C. 1512 C2, which is two of the charges in the Trump case.
Mm-hmm.
So even if they were to rule against us entirely, which we think is very unlikely, there's still a possibility that the Supreme Court could essentially cut out half of the indictment against President Trump. And those are the most broad-reaching charges in the indictment. So one way or another, I think this case is going to look very different by June, if it's even a viable case after the court gets through with both our appeal and the Fisher appeal.
Perfect. Well, thank you so much for your time. I really appreciate it.
Yeah, no, I appreciate the call, and let me know how I can be helpful.
Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.